It would have before the Supreme Court's decision interpreting Proposition 8 back in 2008 that was eventually invalidated by the United States Supreme Court. In our state Supreme Court, the Attorney General took the view that the initiative was, as it was a constitutional measure, was invalid because it was in conflict with provisions in Article 1 of our Constitution guaranteeing equal rights to all people in California. And our Supreme Court said, unfortunately, no constitutional provision is superior to another, and so the Declaration of Equal Rights in Article 1 couldn't trump the Prop 8 provisions. So there's case law decided on point that one constitutional provision does not supersede another. So that's settled case law.
Well, but can I just ask a common sense question?
Sure.
If this is where you were at, why didn't you just simply say so in the measure?
Well, we didn't want to be responsible for creating the rule that the UC is covered unless it's specifically exempted. The rule has been since the creation of the University of California that the UC is exempt unless it is specifically mentioned as being not exempt. And we did not want to be responsible for turning that rule on its head and undermining it, potentially undermining the University of California's constitutional autonomy.
I had even a more simplistic kind of question. I get a lot of people have asked me about this. It seems glaringly apparent it's about a referendum on the tunnels. Why not just phrase it that way?
That has been an argument of the opponents. The measure is not just about a referendum on the tunnels. It's a referendum on state debt. The proponent is concerned. He has been a long time opponent of the tunnels. There's no doubt about that. He's also been very active in getting out his views on state debt issues. In 2014, he ran a series of statewide newspaper advertisements in all the major newspapers in the state, called his Liar Liar campaign, sort of, expressing his views on the state's debt situation and how he thought it was it was getting out of control. So it's really beyond that. He's from Stockton. He was very, I think, affected by the bankruptcy of his hometown, and that's what got him involved in these issues. So it's a confluence of both of those views.
But revenue bonds are more fiscally conservative than GO bonds as far as debt service payments.
Potentially, but they also have less accountability as well to the people who are paying for the projects.
I'm sorry, I apologize, Senator Wynn. Senator Morlock had been before you, then Senator Wynn.
Thank you, Mr. Chair.
Thank you, sir.
Mr. Oneto?
Oneto.
Okay. Why the concern? We were told that we haven't had any abuses with revenue bonds in California. What?
Well, there is. I think the Bay Bridge that was mentioned before. I think that served as some surprise to some folks that it was pitched as a $1.5 billion project, and it ended up costing almost $6 billion. Costing almost $7 billion. I think the voters want to know. I think that the almost 1 million people who signed this petition for this measure want to know that when they're told what a project's going to cost, that they're going to pay for, whether they're paying out of their tax funds or out of their bridge tolls or out of their electricity bill or out of their water bill, that they have accurate information on how much it's going to cost.
So then, I have not gone deep into the Bay Bridge. Is that $7 billion? Is that all? Revenue bonds, or is
it's $7 billion in revenue bonds, and then they're still trying to figure out how to fix some of the problems. So I don't know, Senator, what the final number will be, but it's $6 billion and plus and growing.
So they're anticipating enough toll revenues to pay $7 billion.
I don't know what the numbers look like, but I do believe that we've been paying off the original bridge up until very recently that was constructed in the 1930s. So it probably has a long ways to go before they'll pay that off.
Well, it just seems as if that's something that we need to explore, because that's like that's crazy. But anyway, I'm opining, but a $7 billion bridge, I don't know who even buys those bonds. But okay, my next question is, how many ballot measures has your firm written over the years?
We've been involved in either for or against over 300 ballot measures in our firm's history. Yes, sir.
How many have you written personally?
Dozens.
Is that right? Okay, thank you. How did you pick the $2 billion? You was there some study done, or?
Well, that wasn't my decision alone. That was a team effort with a proponent and all the folks involved in this. But the $2 billion threshold was chosen because it's really a limit where, in the proponent's view and in the supporters' view, that you cross a threshold into projects that really affect millions of people because of the size of the project, and you're not really interfering with, sort of more localized regional projects. You're getting at those projects, even if they are in a particular region like the Bay Bridge, they're affecting millions of people that use that facility are going to have to repay that facility. It gets it really into sort of the real big leagues in terms of
So the treasurer raised the concern about aggregating, which would be like the Bay Bridge example.
Yeah, that issue again about refunding or reissuing.
Yeah.
General obligation bonds, in the boilerplate in the back of the acts, they include that authorization to refund a reobligation. That same language would just be included in the revenue bond measures that go to the voters, and so that authority would just be baked into the measure, so that would be available. This body would be writing those, putting those acts on the ballot. I'm sure that authority would be included in there.
But that's inconsistent with the language of the measure. You say that like it means nothing. You've just said it's $2 billion.
Right.
And so now the legislature, in contrary to the constitutional provision that you seek to pass, is then going to put an initiative on the ballot or a measure on the ballot that says it's okay to refinance when the refinance may be over $2 billion. That makes no sense whatsoever.
Well, Senator, so if I were advising on how to draft the measure, you would include the cost of the project and then include it within there as well the cost of of any financing, or the project includes whatever cost it is to build the project plus the authorization to because voter approval is what's required. Once the voters have approved that authority would belong to the treasurer or whoever it's given to.
And then you mentioned 78% approval rate of bond measures. What was the period again?
1900 until 2014. So
100 years of, because recently it's almost been 90%. And so I found your statistic rather interesting. I saw a governor lose 4 ballot measures in early, I think it was 2003 or 4. And then the next year he says, oh, look at these bond measures are passing, so I say build it. And all of a sudden we have massive, debt again. Why, Mr. Chair, is the LAO not included on the panel?
Here?
Yeah, because he mentioned the LAO a couple times in its report. Well, why aren't they here? They're usually the first ones up.
Well, we had the treasurer up because we thought that it was my decision, and certainly we discussed this with the Assembly Appropriations Committee, and I felt that the treasurer as opposed to the LAO, because they actually are in the experience of issuing the bonds, and the question here is what's the practical effect in the marketplace, what's that look like, so rather than the policy where we have his briefing here and in the paper here, but really to try to get the practical, because we have a short window for a hearing. I thought that was the best use of time, so to the extent we can, happy to follow up with that if you'd like.
No, I just want to thank you for a great discussion that just seems to only impact a couple of projects, so it's a great debate. But so half of me says it's de minimis, and the other half is that we should have more voter involvement. So I appreciate the discussion today. Thank you very much. Thank you.
Thank you, Senator.
Senator Nguyen.
Thank you. Actually, Mr. Chairman, I want to follow up on the LAO. I appreciate your comments and the decision made, but my understanding, the LAO tends to be our advisors when issues relating to the budget. So I think it would have been helpful if they were here just to kind of balance and give us more of a budget analysis and not so much of, the marketplace and all that other stuff that the Treasurer's Office was very invaluable, and we needed him here as well. But I think, maybe when we talk about issues that are related to the budget or some kind of impact, it'd be great to have the LAO. The question is, isn't it true that local government agency of all types are expressly exempt from this measure?
That's true, Senator. Yes.
How does it work if the state is part of a JPA?
If the state is part of a JPA with a local government, that JPA would be covered by the measure's terms because the state would have involvement, so that needs to be a partially state project.
So are we talking about specific projects of the state involvement or the state's involvement in that JPA in general? Here's why. When the 405 freeway that I spoke to earlier, currently the Orange County Transportation Authority said that there will be no state funds. It will be all Orange County based. It'll be our bonds and et cetera, whatever, however they want to however they want to structure, but it won't involve state or federal money. But the state is involved in all other and overall of other things with OCTA. So is it specific projects or is it just in general that they're involved in a JPA?
So it has to be a state bond over $2 billion in a project that's owned, operated, managed, financed by the state. So, Senator, in your example, since there's no state revenue bonds, the voter approval would not be required because this is going after state revenue bonds, this measure.
Okay, so it's specific projects and not
specific
just
projects.
Overall
That's
involvement
right.
with an agency.
Specific projects with more than $2 billion in state revenue bonds.
Well, at least as of right now, I don't know if there is any. I don't want to get that on record saying that there isn't any, and then all of a sudden, a year from now, they decide, well, we probably need the states.
And again, it's the $2 billion threshold.
Yeah,
pretty high hurdle.
Well, we're well over 1.5, I believe now. So, and that's only been a few years since I've been involved as a county supervisor.
Well, is that for the cost of the entire?
It's for the entire project.
Entire project, not just the toll road.
I believe it's the entire project, not just a toll.
See, if revenue bonds were going to be financed with tolls, the revenue bonds could only pay for the toll road portion of the project. Otherwise, it would turn that toll into a tax under Article 13C because one payer would be paying for the entire project. That would require voter approval anyway. So
they're also using money from their Measure M.
The local,
well. So
the local self-help money.
Yeah, the self tax and then the toll separate. So.
Yep.
Thank you.
Thank you.
Any further? Bill? Chairwoman Weber, anything?
No, just one question. I guess you've mentioned and I know nothing about the bridge that was built, but how would your measure have prevented that from going from, say, a $2 billion project that was approved and end up being $6 or $7 billion?
Well, I would argue that if there was a threat of voter approval at $2 billion, we may have actually gotten a $1.5 billion bridge and saved the voters maybe $5 billion. Or it would just require the state to do a better job of planning, working harder, working smarter to figure out what it was really going to cost.
Or we would have had a half a bridge?
No, I don't think that would happen because the state is going to have to do a better job of telling voters what the costs are. They're going to have to go for the lower cost bridge, and the state will have to be smart enough to build in. They'll have to plan for cost overruns, delays, but the state can do that, and they'll have to put that in the final cost package and present it to the voters if it's over $2 billion. If it's not, they won't. But it'll force them to provide more sunshine into the process and more accountability to the voters. That's what it'll do.
I just find it interesting that you think that will happen. And I only say that because, I was involved in a whole bunch of school projects and building projects, and even though you put all the details in and you put everything you think this school's going to cost, and there are always cost overruns. And do you stop the project because you no longer can meet your budget? I just built a house, the same thing, okay?
Yeah.
I didn't want to half a house. So it cost me a little bit more than I had anticipated with all the best planning in the world. So I'm just trying to figure out how this measure would have prevented it. I think sometimes we come up with ideas that are great, sounds good, and then when the rubber meets the road or when the practicality of the implementation occurs, it becomes a different thing. So I was just trying to figure out what was in the measure that would prevent it from becoming that, or would you just stop the project, or would we have to go back, hold the project up and go back to another vote? How would it operate?
It's within the state's capacity, the state planners, to make those projections. People do that. Governments do that. This will require them to maybe do it a little better, maybe do it at all, because it's not happening really much. I think in some instances that's the rationale for the measure. But overruns can be projected. And that's how budgeting is done, right? So this will just require more sunshine, more accountability, maybe a little more honesty on project costs. That's what will happen. And in terms of, when the measure could go on the ballot, will it constrain infrastructure? I've heard some folks say that it can only go on November ballots. Under the Elections Code in California, voter-initiated measures can only go on November. Measures put on by the legislature can go on June or November. Also, the legislature can call a special election at any time it chooses. That last happened in 2009 relating to the budget. So there's recent history on that as well.
Interesting.
Senator Eggman.
Thank you. Thank you for your question, Dr. Weber. And you weren't here when I was asking questions previously about shouldn't any project go before. We have a $17 billion Delta Tunnels project. It's kind of the elephant in the room going forward. And shouldn't that get a vote of the people, since it was voted on and voted down in 1982, and it certainly has statewide impact. And to your point, I'm also in the middle of a remodel that is from hell. I mean, it's a wonderful experience, and I think that the state, unlike me, has more experience at projects, right? So now at this point, I'm saying, oh, I probably should have done this, or I probably should have done that. But in my own, limited experience, it was harder to be able to project that. So I think what you're saying is that if we were to have a project, say the Delta Tunnels, for $17 billion that will have statewide impact, will not create an extra drop of water that has already been voted down by the voters before. So if we were to have that, if the state were to have to go out and say, and will be paid by voters and ratepayers will be on the hook for this. So if we had to put that on the ballot to say, this is what it's going to cost, this is who's going to pay for it, so the voters would know in advance of that. And I think we have a great example with the high-speed rail. That was another major project that went before the voters. The voters agreed with it, and now the voters are feeling, unhappy that it didn't work out the way they thought. The costs are overrun. So I think, given that experience, I think if you were to do a remodel again, if I were to do a remodel again, we would have more experience to be able to plan it out a little bit better, maybe bring in different experts at different points in the construction. And I would think that the state has learned from their experience with high-speed rail about if we were going to do another project of that magnitude that has statewide impact that everyday voters and ratepayers are going to be paying for, we would be able to lay out the plan a little bit more transparently. Would that be correct?
That's exactly correct. That's what the intent is.
Thank you.
Any further? Look, the question is that it's raised by those other projects isn't what's before us. What's before us is a proposed constitutional amendment that you propose to put before the people. And just one quick thing I want to put in the record here, because you talked about how your legal interpretation of how the Constitution works. I want to reference Proposition 13 when it was passed. There was a section of banking and corporate tax that allowed for a simple majority of banking and corporate tax, and that was superseded by Prop 13. So for whatever reason is, I know you're not the Supreme Court in terms of how the decision's being made here. I think just as someone who's an old bond lawyer who used to do this stuff years ago, I know that the finance community is a different institution. They work differently. This notion of the courts are going to make interpretations that, this is the way it's going to happen based upon your experience, which certainly may be vast, but the notion of how this actually works, what the chilling effect is. It's the reason why I wanted the treasurer as the opening, because he is the face of the marketplace and how they price this, how they make these determinations. What you're really trying to get to here is risk. And what's the risk versus what's on the taxpayer and where the books are as an accountant, where the debt is. Is this debt on the books? Does this affect our rating and the like? But let me start with this. I want to pass this out to you in this. You drafted this initiative?
Our law firm drafted it.
Okay, good.
Senator.
If you talk about, if you can pass this out in Section 2, Paragraph C, you talk about, according to a 2014 report from California's independent nonpartisan legislative analyst, the state of California is carrying a $340 billion public debt, and you address a document called Legislative Analyst Office Addressing California's Key Liabilities dated March 7th. Now, the only document I could find is May 7th, not March 7th, but this is in your constitutional provision. What I wanted to ask you as you take a look at this document, you're saying $340 billion that you're asking the voters to read. I'm asking you to turn to page 7 of that document, which is the last page of the extracted exhibits here, and it sets forth the $340 billion you mentioned. It talks about retirement. It talks about Prop 98. It talks about CalPERS. I want to know, of this $340 billion that you're representing to the public, how much of this is revenue bonds, which is the subject matter of this initiative?
Well, Senator, this measure is not going to solve the state's entire debt problem all in one fell swoop. I do know that as of earlier, the last time I checked, which is in the last 6 to 10 months, the state was carrying $17 billion in lease revenue bond debt. That is our revenue bonds being paid out of the state general fund. Taxpayer dollars are being paid. So there's a $17 billion, I don't want to call it a problem, but there's a $17 billion issue there that this measure would directly affect. Voters would get the opportunity to maybe participate in that a little more than they are now.
Well, just so you know, the document before you that you referenced in the constitutional provision you're citing says $10.2 billion.
It went up. It went up after that, but yes.
Yeah, but all I'm suggesting to you is that. What I want to know is, look, you're talking about transparency with the people and getting information before the people. I wanted to just briefly just have you an opportunity to explain why you put the $340 billion number when, in fact, the number that you're talking about is only $10 billion. What was your thinking about that?
It's getting at starting to make progress, Senator. As I said, we're not going to solve the entire problem all at once. I think if you look on your chart, some of the larger numbers are caught up in federal constitutional contract impairment issues that I don't think we're going to get in today in terms of CalSTRS and CalPERS and the California rule and all those types of things. But this measure is focused on the very real tens of billions of dollars in revenue bond debt that the state carries that our campaign would like to give the voters a role in and give this legislature a role in that it currently doesn't have.
But do you really think just me to you,
yes,
nobody
sir.
Else listening, just me and you. Forget about all those millions of people that are watching. Do you really think that's an honest statement? When you come here and you just talk to members of this committee, that you talked about transparency and honesty in numbers, that you get out there and your opening paragraph is this number that is just gigantic, and yet it's not at all relevant to the facts? Is that, in your judgment as a lawyer, your obligation to tell the truth, is that, it's political gobbledygook. I get you can say that in political ads, but you're asking to put this in the Constitution of the state of California. Is that something that's a fair statement in your judgment?
On a technical,
just me and you.
Sir. On a technical point, the fines and declarations don't go into the Constitution. Only the portions starting under Section 4 of our measure actually go into the Constitution.
So you're going to the voters. You're telling the voters this is what the story is.
And so I think the use of this number is sort of, it's a good reference point. There's a lot of coming revenue bond debt that's not included in the document that you have here. We haven't issued the $70 billion in revenue bonds for the train yet. Okay, this measure will have a role in that. We haven't issued the $17 billion, or some people say $30 billion for the so-called California water fix. This measure will address that. So there's, right there, there's over $100 billion in revenue bond debt that the state may be taking on, that this measure will give the voters and give the legislature a role in. So I think that is very real. And I think this, we can't cite what hasn't happened yet, but those are definitely on the horizon. So that we use the information that was available.
What's the rational relationship between this measure and pensions?
I don't think as of today, I don't know of any revenue bonds that have been issued for pensions, although at the local level they have issued bonds for pensions. That was part of Stockton's bankruptcy.
Okay, so the Treasurer talked about this notion of general obligation bonds that require you can actually have a refinancing that you don't have in this measure. So it's your legal interpretation that despite you're putting this in the Constitution, this refinancing that you're talking about is permitted here, even though the amount may be in excess of $2 billion.
Of the refunding, well, yes, turning again to the language, I think is where our treasurer says a good place to start, begin at the beginning. A vote is required for any single project. Now, I have serious reservations that the courts will find a refunding or refinancing to be a project. I have my doubts about that, serious doubts about that.
But the upshot is that the way the Treasurer's Office works, as you heard them testify here earlier, I think, if I heard it correctly, is that often in order to get a better insurance rate, they bundle. I remember years ago I saw this happen. They'll bundle a bunch of loans to get a better rate. Let me just pass out to you something that Orange County did brilliantly, and Senator Bates talks about saving Orange County $975 million. I don't know if you were there at the time, but this is a state-created, state partnership in what's called the Foothill Eastern Transportation Corridor. Legally, they'd fall within your definition of the state, and they refinanced $2.3 billion, bundling a series of different freeways together in order to refinance. And according to now Senator Bates, then Supervisor Bates, she talks about saving $975 million in taxpayer dollars. How could she, under the circumstances, and state clearly was a part of this JPA, how would she have been able to do that? You wait for vote of the people, you may miss the window for purposes of capturing the interest.
So a refunding or refinancing is just shuffling around paper. That's all you're doing. I don't think the courts are going to, I'm confident the courts are not going to find that to be a project. That's not a project.
Will your law firm personally guarantee that? Because what if you're wrong? I'm serious. You're here testifying.
Yes, sir.
What if you're wrong?
Based on the hundreds of cases that I have read in my life on the court's rules of interpretation of ballot measures, I think that is a very low probability of that happening.
But what if you're wrong? In other words, you'll see here in a moment I've got some of the standards that bond lawyers use for purposes of making opinions. The way the bond market works, as best as I can understand it as an outsider, is that these things rely on excellent lawyers who take a very conservative view as to what constitutes their ability to do a reliance letter. And they have what's called an unqualified opinion. I'm going to distribute those to you in a moment so you can take a look at it. But the notion is that you opine as to this, and look, you may be right, I don't know. But we're dealing in writing a constitution, fundamentally changing the financing structures that the Treasurer testified to through the questioning of Senator Morlock hasn't proven to be a problem in terms of what you're seeking to do. And I just raised that. We'll send that to you in a moment. Now, I want to also give to you the California Earthquake Authority. Now, you referenced the fact that there's a limitation.
Yes.
We'll distribute, that's this document here, that there's a limitation statutorily, but certainly, wouldn't you say it's fair that if there was a major event, earthquake event that we know is going to happen, right? We know through the history is going to happen, that one of the first acts the legislature would do would to raise that number much higher statutorily than the billion, could be 10 billion, whatever the number is needed to match if the feds actually come through, what that looks like, and that then is going to have to go on a ballot for the vote of the people?
Well, the California Earthquake Authority currently has over $11 billion in claim-paying capacity built up, plus the $1 billion revenue bond threshold, so the legislature could double that immediately and not run into any problems. So, I mean, I guess in the one in a, I'm not a seismologist, so I don't know how likely an earthquake is to cause that much damage, but I do know that there's at least $12 billion standing out there waiting to be deployed in the event of an earthquake. I do know that.
Okay. And what if the event and the occurrence exceeds $12 billion? I mean, you're making these decisions the question is, we have a financing mechanism that works, that doesn't default, and the question is, look, you can interpret these things, and you have specifically indicated that this requires judicial interpretation. So don't you think it's fair that judges don't make decisions over the weekend? They take time. It goes up the ladder. There's contrary decisions by the judicial branch of government. So the effect is, certainly in the bond councils with whom I have just kind of asked about, like, what does this look like and what do you think? It's going to create tremendous uncertainty in the process that's going to basically put a chilling effect. it seems to me, I'd love to your thoughts on this, on the ability for the state to engage in its day-to-day business.